Living Trust Amendment and Restatement in Syracuse, New York. A living trust is built to last decades, but the life it protects rarely stays still. Marriages, births, deaths, moves across state lines, and shifts in New York tax law can all leave a once perfect plan badly out of step with your current wishes. When that happens, Syracuse families need a clear path to fix the problem without starting over from scratch. Davies Law Firm has served Syracuse and surrounding Onondaga County communities since 1993, helping more than 10,000 clients build and maintain living trust estate plans. A living trust amendment is a separate legal document that changes one or more specific provisions of an existing revocable living trust without replacing the original trust agreement. The amendment is signed and dated, references the original trust by its name and date, identifies exactly which sections are being changed, and is then attached to the trust file. Amendments work well for narrow, targeted changes, like adding a new grandchild as a contingent beneficiary, or swapping out a successor trustee who has moved out of state. The legal authority for amending a revocable trust in New York comes from the Estates, Powers, and Trusts Law, Section 7, 1.17. The statute requires that any amendment be in writing, executed by the trustor, and either acknowledged before a notary public or signed in the presence of two witnesses who also sign. A trust restatement is a complete rewrite of the trust agreement that keeps the original trust's name, date, and tax identification number while replacing all of the internal terms. Unlike an amendment, which sits alongside the original document, a restatement absorbs and supersedes every prior version. Because the trust itself is not revoked, every asset already titled in the trust's name stays in the trust. Real estate deeds, brokerage accounts, and beneficiary designations that point to the trust do not need to be retitled or refiled. A restatement is the better tool when the changes you want to make are too numerous, too interconnected, or too sweeping to handle through one or two amendments. Multiple prior amendments can make a trust document hard for trustees, banks, and title companies to interpret. Major life changes like divorce, remarriage, the death of a spouse, or the birth of grandchildren often require rethinking distribution provisions and trustee succession at the same time. Significant changes in New York or federal tax law can justify a full rewrite of tax-sensitive provisions throughout the trust. Trust funding is the process of transferring assets into the name of the trust, and it is often the most time-consuming part of building a living trust estate plan. A restatement preserves that work because the trust's identity does not change, protecting the hard-won funding families have already completed. Frederick P. Davies founded the law firm in 1993 to focus exclusively on estate and long-term planning for central New York families. William P. Davies is a partner who graduated magna cum laude from Albany Law School and earned an LLM in estate planning from the University of Miami School of Law. It is recommended to review your trust at least every 3 to 5 years and after any significant life or financial event. The review does not always lead to changes, but it gives you a chance to catch problems before they become expensive for your family. Call Davies Law Firm at 315-472-6511, located at 210 East Fayette Street, Syracuse, New York, 13202, to schedule your consultation about updating your living trust estate plan.